I'm going to get started if I can. I first of all want to welcome all of those who were here yesterday back. I'm always amazed when I do a two-day program that people actually decide to come the second day. I figure I'm going to come back to an empty room. To those of you who are sharing a ticket with somebody else in your office, welcome. We had a very good day yesterday, I have to say. And the response from all of you has been very positive. I would ask you again to complete your evaluation forms for a number of reasons. If you didn't do your evaluation form from yesterday, do that one, and as well do the evaluation form today for a number of reasons. Number one, certainly evaluating speakers is important, but more than that, we need to know what topics you're interested in. It's all well and good, and I was being semi-facetious yesterday when I said, you know, we pick the topics because I decide what questions I want answered, and then, you know, you guys come along for the ride. But we really do want to know what questions you want answered and what kind of speakers you want, because this is going to be a continuing program. It's going to be an annual event. If timing is problematic, somebody yesterday suggested, well, February would be better than April because we're busy or we're slower, whatever. Let us know that. If you hate this room, let us know that, because with the kinds of numbers that we've got, they're already talking about moving this program off-site. And if the returns come in and everybody says, get us out of here and get us into someplace more comfortable, better air conditioning, whatever, then again, let us know that. Just don't be rude when you fill out the forms. A reminder as well about the specialist program. As I indicated to you, if a lot of you are generalists, you'll be surprised at how many of those little boxes you can tick off because you've done everything. It's the person who only does mortgage work or the mega deals that would have more difficulty because they can't even tick off the box that says, in the last 5 years, I've done a house deal. You can probably tick off a whole lot of boxes. And lastly, the bar admission course. It is, as I said yesterday, they are looking for instructors in real property. It's a great place to, as an instructor, to fine-tune your skills, your knowledge, to meet a whole bunch of other nice people who are doing exactly the same thing, and as well to meet a whole lot of nice students and see what the upcoming generation is all about, and how little they learned in law school about real estate. And the last point, again, is there is a change in the schedule. For those of you who are very excited to be hearing Jeffrey Lem this morning, you're not going to. You're going to be very excited again to hear Brian Bucknall in Jeffrey's place, and Jeffrey will be here this afternoon. We've got a jam-packed program for today with a lot of people who don't understand the meaning of 25 minutes. Which is their allotted time. So I'm going to get rolling right now so that we can keep on schedule. Izaak De Rijcke is going to be talking to us about surveys. Izaak is probably the most qualified lawyer in the province to talk about surveys because he is a surveyor. So he really understands things that we fake when it comes to, is it a good survey, adverse possession, how good's an R plan, old plans, etc. So without further ado, Izaak De Rijcke.
Thanks very much, Sid. Thank you. And welcome again, everybody. The topic, surveys and descriptions, is the one that I'm going to be dealing with first out, and I'm going to correct Sid right off the bat. I get 30 minutes. I don't get 25, and I'm probably going to use all 30 if I can get away with it. speak right into the mic, I will. Thank you. 2 years ago, the special lectures topic, the theme 2 years ago, was in fact real estate. And many of you will have gone to those special lectures in 2002. And the theme, the title for the whole special lectures day was Conquering the Complexities. I was asked by Sid to present a paper at that time, and almost defiantly, I entitled it Defining the Parcel, the Complexity Continues. In other words, the complexity and parcel definition doesn't lend itself easily to being conquered. Doesn't mean that we can't make headway in getting clarity and some understanding of what descriptions and surveys are about, but conquering it completely, I still think we're a long ways off. Out of that experience, Sid and I came to realize that there still exists a need to understand some of the basics of what surveys are, what surveyors do, and although we use these surveys in so many transactions, we find them in our title searches that our freelancers and our staff get from the registry offices. We rely on them. We pass them on to our clients who are entitled to rely on them. And unfortunately, what they seem to be is not always what in fact they are. What I'm going to try and do this morning is use pictures. The only way to talk about a survey, which is a graphic representation of a description, an attempt to map out the boundaries of the parcel, the entity which is the subject of what we talk about when we talk about ownership or title. The only way I can talk about it is by using pictures. In explaining what surveyors do, I'm hoping to give you some insight into what the product of their work in fact is. Different kinds of survey plans stand for different things and mean different things. We'll look at different types in order to recognize better what we're in fact looking at. And then lastly, at the end of my part this morning, I just want to touch on the notion that with land titles now being so prevalent throughout Ontario, that we're going to see the end of adverse possession. It's going to come to an end and we don't need to worry about it anymore. And along with its death, there's going to be stability in boundaries. We're going to end up having property lines that can be fixed. In fact, we can almost say that our parcel definition is as guaranteed as the title that we get from land titles. I call it the fiction of a guaranteed parcel. LTCQ and the conversion to land titles without giving notice is another, and it's the last item that I'll be talking about this morning, last development to have introduced some startling new issues that we're going to see coming to a head in the coming months or years. In the materials, you'll find pretty much the complete selection of slides that I've prepared for this morning. The first one is just a point form summary. What do surveyors do? Well, all of surveyors' activities on the ground can be classified into two different kinds. First of all, there's the traditional, the one that most of you are familiar with. It's the stereotype. Surveyors lay out or set out on the ground new boundaries, new property lines. In doing so, you understand the result is the creation of new parcels. And there's legislation that authorizes this to take place, such as, for example, in laying out a new township, the authority is found in the Surveys Act. Laying out new lots, streets, in plans of subdivision, the authority is found in the Registry Act and the Land Titles Act. The creation of new condominium units, it's the Condo Act. Each of these various pieces of legislation include language which refers to the true and unalterable boundaries of the parcel. Generally speaking, the language goes on to say that they are defined by the monuments, posts, blazed lines on the ground. And that is, if there's any conflict or discrepancy, that is going to prevail over any measurement or any call in a meets and bounds description or any distance that might be shown on a plan. So it's the work on the ground, it's the things that are set in the ground, it is the blazes and the marks put on trees and so on that define where in fact that boundary is on the ground, not necessarily what theoretically might appear on the plan in front of you. What seems to be less understood is the second equally intensive amount of work that surveyors do as well, and that is called retracement. Retracement is the operative word, and in Ontario, it's somewhat of a misunderstood activity completely, and perhaps I haven't totally figured out why. It may be in part because there is, certainly in the civil law system, in many European jurisdictions as well as in Quebec, we have the notion that property lines are the property of the state. And most surveyors work as state employees. They come out and set the property lines for property owners, and their arrival marks finality. What I've done is in the ground, and I have just performed a final act in locating your property lines. In Ontario, that's not the case. Retracement is an assessment of evidence. It's conducting research. It's comparing what you find on the ground with what surveyors have done before. All of that activity is with a view to forming an opinion of boundaries on the ground that already exist but don't necessarily have the clarity associated with them which allows for two neighboring owners to, without disagreement, simply locate it on the ground and say, yes, there's consensus here and this is where it is. Justice Corbett has summarized the operative mechanism here with language in the Divisional Court decision in Richmond Hill Furriers. This is a case that involved an appeal under the Boundaries Act, and her language speaks loud and clear. It isn't just the planting of a monument or the drawing of a line on a plan that creates a boundary. No, there must be something else done. Something else has to be done for the boundary to come into existence, such as an owner signing a certificate on a plan of subdivision and then registering it, such as an owner conveying by deed a piece of land that is severed by meets and bounds description or by way of a reference plan. Let's take a look at different kinds of plans. Everything seems to have its origin in a Crown patent, and that's certainly the truth with boundaries and surveys as well. Township surveys were needed in order to divvy up Crown lands so that properties could be patented, settlers put on the ground. We talk, as surveyors, we understand and talk about different systems of township survey. Systems exist because there are different widths for concessions, different widths for lots, but once you're into a particular system of township survey, you can count on the standard distance between concession lines, the standard distance between lot lines being consistent throughout the whole of the township, in theory. What happens on the ground is, of course, another matter. And although you can look at this particular slide at the top of page 3, I'm giving you an example of what a township plan looks like. This is known as the double front system of township survey. And what it is a grid pattern where surveyors were instructed to run the concession lines. So they would literally run through the woods up and down the concession lines in the north direction, then at the top of the township, move over to the next concession and run on an astronomic bearing in a southerly direction, planting posts in the ground as they went along at the prescribed lot widths. Every fifth lot, there'd be an extra 66 feet or one chain taken into account for the width of a road allowance. This is an example of one of 7 different types of township surveys. large undertakings. Most of this happened in the early 1800s. The Canadian Shield, Muskokas, Halliburton, most of that happened in the latter part of the 19th century. The objective, land settlement policy objective on the part of the Crown was get the settlers on the ground, get them to clear it, start farming, produce families, create settlers who could ultimately be taxed and drawn upon for military enlistment. This is the type of policy that drove why surveys for townships were done as quickly and in the manner that they were. Here's another example of one of 7 different township plans. This kind of township plan is called the 1,000-acre sectional township. Cottage country is rife with 1,000-acre sectional townships. This system of survey prevailed Lake Muskoka, Lake Joseph, all the way through Algonquin Park. This is the township system that applies to the Canadian Shield. Now, it is in the Surveys Act that the language that I referred to earlier is found, and you can see the quote at the bottom of this next slide. Every line, boundary, and corner established, etc., is a true and unalterable line, boundary, or corner as the post may be, and shall be deemed to be defined by the original posts or blaze trees in the original survey thereof. A theoretic way in which a parcel is created, identified, and marked on the ground by only 2 points. 2 points at the 2 front corners, theoretically defines a complete rectangle. Outlined in yellow on this particular slide, you see essentially a 100-acre parcel, and the 2 posts set at the 2 front corners is all that was done in the 1800s to mark that parcel for a settler who supposedly came to clear the land and start farming. Now, this left it up to settlers, to pioneers, to resort to their own abilities, their own resources, to go ahead and then create fencing, to clear the land and make sure that they weren't doing their neighbors too much of a favor. It was hard work, it's a tough existence, and the last thing they needed was to pay money to a surveyor to come out and do the work for them. Sound familiar? Nobody wants to pay for surveys today, which is fine. They didn't back then either, so they did the best they could. They ended up, in many cases, building fences using the resources available. And they didn't always accord 100% with where theoretically it ought to have been placed. Case law over the decades recognized this fact and has supported the permanence and the reliability of these lines as they came to be actualized on the ground by settlers as being the real property lines. Okay? So you look at a township plan and you look at the configuration of all these various lots and concessions, and you hold it in front of you and you look at it with your client in your office, and the finger points to, yes, it's this lot in this concession that you're buying. And for many years, that sufficed. It worked fine. Certainly for patenting and getting people on the ground, the system worked. It was fast and efficient. But it wasn't free of problems. Lakes, rivers, other topographic features as exist throughout the Canadian Shield were interspersed and existed topographically on the ground within this grid network of lots and concessions. Now, let me just use this particular slide as an example. This is a classic case of what goes wrong when you use 2 points on the ground to define a rectangle, and parts of the rectangle are broken up or impacted upon by a natural body, such as in this case, a lake. Lake Muskoka, to be exact. We have a lot line between lots 21 and 22. And you see how from the line between 21 and 22, as it moves westerly, it eventually hits the water. It stops, and then when it reaches land on the other side, the theoretic grid system picks up the lot line again, and it continues to another concession road. Around 1860, this plan was prepared by the surveyor. It was done on the basis of him doing the field work, but you know from the system of survey that no posts would have been planted at that particular corner. There are two circles that I've drawn in for you. The one on the right is not a line or a corner that would either have been run or posted in the original survey. So that is theoretically out there as a legal boundary, but nobody on the ground can yet go out there and easily locate it. Over time, in 1920 to be exact, I'm giving you here an example of a subdivision. The owner of Lot 21 creates a subdivision of lots along the lake, ranging from Lot 35 all the way through to Lot 52 in the bottom left corner. What you see in this particular plan from 1920 for the first time is the possibility that the lot line between 21 and 22, in fact, creates some ownership in Lot 22 for the waterfront property that from the plan in the township looks as if it belonged completely in Lot 21. You see what I'm saying here? It supposedly stops. When it hits the water, doesn't pick up again until you're well on the other side of the shore. But in 1920, this plan suggests that, well, maybe there is some additional water frontage within Lot 22, arcing all the way around Lake Muskoka. Go out there and take a look in the wintertime. You stand on the shore, a bit of high ground, and you look to the west, and you see a few projections of dry land into the frozen surface of Lake Muskoka. Surveyor does a reference plan for the owner of Lot 22, and what does he do but picks up these points, these three projections, and calls them parts 2, 3, and 4. He says that these are part of Lot 22. I'm now the owner of Lot 22, and my property is described simply Lot 22, Concession Y in this particular township. That's all my deed says. What do I own on the ground? The system counted on you being able to go to the ground and figure this out. Until somebody did it, nobody realized that maybe me now, as owner of Lot 22, owns the waterfront. Maybe I'm the one who can now subdivide. Or even better, prevent my neighbor in Lot 21 from subdividing something that he needs to buy from me first. Here it is again, a bit of a better view. You can appreciate here from this picture on the ground, when you're up a little bit higher in elevation and you look across the water in a westerly direction, you see the three projecting points of land. Obviously, the owner of Lot 21 isn't going to stand by and allow this to happen. Another surveyor comes along, and we now see a Boundaries Act plan coming forward. And the owner of Lot 21 seeks an order under the Act that the boundary, the northerly boundary, if you will, for Lot 21 is the heavy line. If the northerly boundary of Lot 21 is the heavy line, then obviously the owner of Lot 22 has no title in any parts that might project into Lake Muskoka. Ultimately, the decision was in favor and supported the applicant. The applicant, in this case, being the owner of Lot 21, and the rationale for that type of decision and outcome is given. Lots of other kinds of Crown land plans. Township plans are only an example. Crown land location plans are used in cottage country all over the place. Typically, you also find them for water lots. A grant or a patent of the bed of Lake Ontario or any of the Great Lakes in Crown Ontario's title is done by way of a Crown land location plan. An example, this typically is what you see. Some of them are registered on title, some of them are not. This is a more recent version, even though it might be dated 1959. This kind of product essentially allows for the Crown to issue a patent to a parcel known as Crown Land Location 332. Here's another interesting example of what you also find as a plan that has almost a dual type role. First of all, it's a Crown land location plan for the issuance of a patent to lots 10 and 11 from the Crown. What then also happens is the Crown chooses to register this as a plan of subdivision. The plan is also registered in the Land Registry Office, and it is assigned number 162. This is summarized with the points or bullets on the next slide. Ultimately, the owner of Lot 11 discovers that the cottage that had been built on Lot 11, in fact, was built on the shore road allowance in front of it. Needs a shore road allowance closing, needs a conveyance of the closed road in order to gain title to the land on which the improvement has been built. How's that done? A reference plan used to define the part of the shore road allowance that is to be closed and then conveyed to the owner of Lot 11. So this is an example of a survey that is used to define a new parcel being just a limited or a short portion of the shore road allowance that is to be conveyed by the municipality to the upland owner, in this case, Lot 11. So let's talk somewhat about reference plans. You're probably most familiar with reference plans as one of the most common tools for describing properties. Reference plans essentially do the two kinds of things that I mentioned at the outset. Remember, the stereotype role for surveyors is to create new boundaries. The less understood role of surveyors is to retrace existing boundaries. Reference plans do both. When you look at a reference plan and it's laid out on your desk in front of you, ask yourself the question, am I looking at a plan that creates a new boundary by creating parts that are then the subject of conveyancing? Or is it a plan that attempts to retrace a previously created legal boundary, and I'm now seeing a surveyor's opinion expressed in this plan? That's essentially what these bullets summarize in this particular slide. A classic appearance for a reference plan is this. The characteristic two squares in the top right corner are almost always present. The requisition to deposit, and then the recording details from the land registrar in the top right box. Reference plans are deposited, subdivision plans are registered. The distinction is crucial under the Planning Act. Parts on a reference plan are not lots. Without a consent from a land division committee or a committee of adjustment, parts are not amenable to compliance with the Planning Act. This next example is yet another version of why reference plans have become such a powerful tool. In conveyancing, the word reference plan is short for what they initially were called when first introduced in the early 60s. They used to be called description reference plans because they were an attempt to create a graphic version of a textual meets and bounds description. Imagine trying to plot out a meets and bounds description with curve and arc information for realigning, as in this particular reference plan, portions of Lot 35, range 2 in the broken front concession, which now need to be conveyed for opening up parts of Winter Gardens Trail. Try and figure that out. The textual part would involve points of commencement, radius of curvature, arcs, bearings and distances, and you'd be pulling your hair trying to figure it out. Here it is. It's mathematically checked. Surveyors depict it in a graphic to scale drawing version, and from this time forward, if you want to deal with the portion of what used to be Winter Gardens Trail, or is opened up as that, it's talked about as part 5, 6, 7, or 8. Much simpler, much more effective. Here's another example of the use of reference plans and why they are such a common tool in your arsenal in conveyancing. The first slide is an illustration of what I describe as two severances. Meets and bounds, they were created in the 40s or 50s, never surveyed. Surveyor goes out, and the two deeds call for 100 feet frontage each. There isn't 200 feet available. What does the surveyor do? Well, eventually, you'll end up getting a reference plan with two parts. The boundary between the two parts, we'll call them A and B, let's say, is a conclusion or an opinion that the surveyor has reached as to where the boundary between parts A and B is on the ground, having assessed all the available information and evidence. Is he fixing that boundary? No. Is he creating it? No, it already exists. What's he doing? He's helping you and understand how to reconcile this 2-foot shortfall on the ground. Until the survey is produced and until you see it, the meets and bounds descriptions may all just match up perfectly. You may be led to believe that you're fine, but in fact, you're 2 feet short of the frontage necessary. The second example is another flip-flop. Part 3 and 2 are the result of what a surveyor has laid out because a meets and bounds description calls for parts 3 and 2 as a parallelogram, created by instrument number M-7416. It's pretty straightforward, right? On the ground, he arrives, and parts 3 and 4 are fenced. Obviously, the seller and the buyer, the farmer and a family member, let's say, fenced what they thought they were conveying, and it isn't anywhere close to what the theoretic description calls for. Highway plans is another commonly encountered plan of survey. Highway plans are going to end up creating all kinds of problems from a conveyancing point of view in terms of understanding what they are. In fact, highway plans, I've been to seminars that the Surveyors Association have put on where the whole day is devoted to just understanding the whole spectrum of highway plans. It is a complex subject. You need to understand what section of the Public Transportation and Highway Improvement Act is being referred to, what's the authority for the plan, what's the purpose of the plan, why was it produced. We've already spoken somewhat about Boundaries Act plans, but it too is only a rare type of plan, although a very useful one if you encounter it. I want to jump forward to a section called subdivision plans. There's some, there's some ambiguity in people's minds as well as to what in fact is a subdivision plan. Because of their significance under the Planning Act, it's important to understand and be able to arrive at the correct opinion as to whether or not a particular plan is or is not a subdivision plan. You need to look at the certificates. You need to look at the legislation that was in force at the time the subdivision plan was produced. Here's a good example of the kind of appearance that you see for subdivision plans. Here's another good example of what you'll encounter today as a modern version of a subdivision plan. Lots, streets, reserves, blocks, all laid out and identified. Judges' plans are another occasionally encountered type of survey plan, and it facilitates, using this example in this slide, the treatment and definition of parcels that already exist. Railroad plans, same type of thing. Railroad plans don't necessarily come into existence just because a railroad is being produced. Some of them are produced in order to close them, and that is commonly done by reference plans. This is an example of a plan that isn't really a survey, it's an engineering sketch drawn right onto the face of a deed. I speak as well about expropriation plans, and there's an example in the material of what they look like. Always be aware that once you've had a portion of your client's property expropriated, the remaining lands, if they used to be the whole of a lot on a plan of subdivision, all of a sudden don't become or remain the whole of a lot on a plan of subdivision. Be aware of SRPRs, as we call them. They used to be called mortgage surveys, plan a building location survey. I've got a few examples of what they look like, and perhaps most important, for purposes of what I want to just finish off with this morning, is survey plan lookalikes. I call them lookalikes because they mask themselves, and I've seen them all too often being passed off as the real McCoy. Survey plan lookalikes can take all kinds of forms. This is a sketch for a building permit application. Looks like it, feels like it, and it's passed off to many purchasers' lawyers as the real McCoy. Severance sketches. People think that they're based on a survey done out on the ground. They're not. Compiled plans. They're within the system, but they're not based on field survey. They don't create new boundaries. Pin maps. Disclaimer in the bottom right corner of every pin map says this is not a plan of survey. It's amazing how many people treat them as if they are. Illegible copies. Photocopied, faxed, and then photocopied again. Attach it as an exhibit to a declaration saying it is the attached survey is a true reflection of current conditions on the ground and there are no improvements other than what is shown on the ground, blah, blah. You're familiar with the language. Use this stuff at your peril. Don't go there, please. Some of these are still kicking around as well. A textual description of what a surveyor has certified even as recently as 1981. Okay. I'm going to stop at this point because my time has run out. Don't hesitate to take a look at the remaining slides at your leisure. One of the most interesting things that we're going to see is the impact of legislation that I've summarized in the second last slide, which refers to Part 8 of the Land Titles Act. I've tried to extract and copy for you, in this particular slide, extracts from the LTA, which from Part 8 in particular deal with how do you reconcile this language with what you encounter in surveys on the ground. Okay, thank you very much.
About 7, 8, 9 years ago, we were all dragged kicking and screaming into the realm of and business of title insurance, and now many of us rely on it for our clients. What it does, unfortunately, is while it does offer certain protections, it also has turned us into something we never thought we would be, and that is insurance agents for our clients. Because every policy isn't the same, and there are some things that policies don't include that maybe should include in any particular situation. Bruce McKenna has been very involved with advising title insurers and in the development of title insurance in this province. And he is going to talk to us for the next 25 minutes on endorsements that you should be considering for your clients on title insurance policies. Bruce.
Now, I've spoken about title insurance a fair bit, and when I agreed to do this presentation, I sent an email back to the organizer and Sidney Troister asking for an angle to make it more fun to do and more useful for you. Sid responded, "There is nothing exciting or worthy of an angle when we talk about endorsements to title insurance policies." And Sid, sometimes I feel that way about the Planning Act. So that's my challenge. I want to do my best to prove Sid wrong. But I'm not mad, because in the same email, Sid also commented that he didn't think that many lawyers, including himself, were asking the right questions when they buy title insurance policies for their clients. And so that's largely what I'm going to talk about today. So Sid gave me the challenge and also the idea of how to approach this. So either way, Sid, boring or entertaining, it's all your fault. Title insurance is no longer an oddity in commercial real estate conveyancing. Using it effectively is an important skill, and there are a number of roles a lawyer must play to do that. The first, the lawyer has to decide whether or not to use it. There are, on the first page of the paper, 5 factors that are often good reasons for using title insurance. You should decide early, because that way will save your client money. Second, the lawyer will assist with the selection of the title insurer. Third, the lawyer will handle all the transactional aspects. Fourth, the lawyer should determine any lender's title insurance needs. Fifth, the lawyer needs to explain to its client both the policy exclusions and the exceptions on titles that are recorded in Schedule B of the title insurance policy. Sixth, the lawyer should ensure that Schedule A is properly completed, that issues such as the amount of insurance, date of policy, name of insured are properly handled. And the final area, where a lawyer maintains a fundamental role in a commercial real estate transaction, even when it's title insured, is with respect to endorsements. A lawyer needs to obtain the correct endorsements to protect the client's interest and ensure that title coverage is adjusted to let the client carry out its business activities on the property. Let's see if I can get this right now. The first section of the paper is entitled Adjusting Coverages to Meet Your Client's Needs, Extras to the Basic Title Policy. And that tries to put endorsements in context. And I won't describe the policy components now. You can read about them in the CCH Real Estate Guide or somewhere else. The basic components are listed on page 3 of the paper and discussed on pages 3 through 7. However, there are 2 parts of the policy that bear particular importance to endorsements. The policy exceptions that are set out in Schedule B, whether they're specific, like a mortgage that's registered on title, or generic, like the standard exceptions that are listed on page 6, and the basic descriptive terms in Schedule A. The second section has too many pages talking about 60 endorsements that are commonly available. It's entitled Endorsements Generally Available for Loan and Owners Policies. This section is being published in the CCH Ontario Real Estate Law Guide, and I hope it'll be a useful resource, but I'm not going to talk too much about it today. The third section is questions that you need to ask yourself or your client to determine the endorsements needed. This is Sid's idea, and I think it's a great one, because if you flip back to page 64, I'll try to give you some examples as to why I think these are useful things for lawyers to be thinking about in commercial title insured transactions. Now, it's my first attempt at going through this process, and I'm sure I'll think of additional questions as I go on. And I've learned a lot preparing them, and I think I'm going to try and use these questions as my checklist in the next transaction. Now, I've grouped the questions into 8 categories. And as I continue, I'm sure I'll figure out better ways to organize these things, but it seems to be a fairly reasonable way to group the various endorsements that I've seen. There are, however, 3 preliminary points that I want to make before we look at each of those categories. The first is that I had originally, and if you would see it in the bullet points that were handed out, I had originally said that it was questions to ask your clients. I didn't say to ask yourself. But I realized as I went through the process of looking at the questions that most of these were questions that I would answer myself as I did my due diligence and looked at the file. For example, when you look at the loan documentation and all the loan endorsements, you look at the loan documentation, you identify what the property is, and you've figured out whether or not you need most of those endorsements just by your own due diligence. The second thing is don't try and get every endorsement you can. That isn't a goal. I once did a file a few years ago with a Canadian lender that had no title insurance experience, and it was represented by a very big Toronto law firm that had very little title insurance experience itself. So what they did is they bought some American books, and they saw lists of endorsements, and they asked for every single endorsement that they thought might possibly be useful. The problem with endorsements is that they modify coverage, and sometimes they take away benefits, sometimes they conflict with other endorsements you've got, sometimes they just don't have any meaning in Ontario law. Now, I was acting for the owner, not the lender, and I did have one session where I said, you know, what do you think that endorsement's going to do for your client? And we did that for about an hour, and I realized that since my client, the owner, wasn't being charged, I could let the lender's lawyers get whatever title insurance they wanted. The basic fact is that the title insurance policy's coverage is pretty good, and you shouldn't be using endorsements just to show how smart you are. You should be using endorsements when you think that there's a problem that needs to be solved. You should imagine, and it's what commonly is done in the States and probably will happen in Canada, that endorsements cost money, okay? And so you should be thinking of spending that money only when you're getting a benefit. The third preliminary point is do this early. You'll have much more success in getting the right endorsements and getting the right coverages for your client if you do it while you're negotiating the policy and selecting the title insurer. You'll also notice at the end of each section of questions, there's an amend policy endorsement, and you can always go back later and ask a title insurer to make an amendment to an existing title insurance policy, but it's going to be based on what the risks in their underwriting requirements are at that time, and it may cost your client money, or they might even refuse you. Okay, in looking at the first of the 8 categories, location and services, Schedule A sets out the municipal address and legal description, and you should ensure that they're correct and that there's no confusion between them. Then you should be asking questions to determine if there's anything that need to be added to the coverage to ensure the property fits the needs of your client. I've done a lot of work with clients in the quick service food industry, Wendy's, Tim Hortons, KFC, Taco Bell, Pizza Hut, and location and access is of fundamental importance to those businesses. It makes a real difference not only that there is access, which every title insurance policy provides, but that there is the specific access that the property currently enjoys. Accordingly, in ensuring the site that I see all the time, the KFC location on Mount Pleasant north of Davisville, I drive by it every day, it was important not only to consider a land abut street endorsement, that you'll see at page 36, or an access endorsement general that you see at page 10, but to get an access endorsement specific. If there wasn't access to Mount Pleasant, that property wasn't as valuable. There are a series of other location and services kinds of endorsements that you consider. If there's a history, if there's a land assembly in the history of the property, you might be looking at a continuity endorsement at page 23. If it's a loan on a property where there might be confusion over the address, there's something in the client's records, there's inconsistent numbering, then you should be looking at an address endorsement, which is at page 12. If there are unusual or important servicing needs, you might be considering a utility facility endorsement at page 39. And finally, there are a series of endorsements that deal with the zoning and use of the property, and those are at pages 61 to 63 of the paper. The second general category is named insured. That relates to the very basic policy provision, who is insured. There are 3 points in Schedule A that deal with this: the name of the insured, the estate or interest that's covered, the entity that holds title to the estate or interest. Now, that's not much of an issue in a loan policy because a loan policy, the insured in a loan policy is each successor in ownership of the indebtedness. So an assignee of the mortgage will be covered. However, many lenders who are concerned about potential liabilities in commercial properties often have title to the mortgage held by a nominee. And you'd want to make sure that both the lender and the nominee were covered. In an owner's policy, it's more difficult because coverage is lost if the insured is not the owner of the property. And obviously, when you have someone acquiring a commercial property and assets are there, the purchaser has something that it wants to do to enhance the value. A marketing plan, a restructuring for tax purposes, a corporate reorganization. And something that enhances the value. When you go through those arrangements, you may well be doing something that would cause a loss of the title insurance coverage because the ownership will change. A simple way to deal with the issue is to get all of the companies that might be involved in this reorganization on the list of named insureds. Now, I acted for John Bidoff when he bought Scott's Restaurants, and it was clear that there was going to be a tax restructuring that would enhance the value of the company. And we could obtain coverage simply by listing all the companies that were being acquired and the acquiring company on Schedule A as named insured. And we thought about having 12 names there, and that would have worked. However, in the end, we went further. We knew of plans for a future joint venture partnership plan. So what we did was we negotiated a specific insured endorsement, allowing us a 1-year window to restructure and add new names. And that's what we got. You see, there is a general insured endorsement that you can see at page 12, but when you look at that, that only works for an internal reorganization. And when you're setting up a limited partnership, that would involve consideration, and you needed to negotiate that endorsement before you started. If the acquiring group is a partnership, you may be looking at an endorsement which is the successor insured endorsement at page 56. If a client is acquiring shares or an interest in a partnership, one thing you have to understand about title insurance policies is that it excludes coverage for matters that are known by an insured. It isn't fair for me to enter into an agreement that affects my title, to buy a title insurance policy without disclosing the agreement, and then make a claim because of that. But with the share purchase, the insured company may actually have historical knowledge of a defect that the share purchaser is not aware of. A solution is the non-imputation endorsement, which is at page 48 of the materials. That excludes the imputation of knowledge from previous officers or partners. Now, I think that the one you'll find in the book isn't good enough, because I think you should get it so that it's broadened to include all prior officers, directors, and shareholders, not the narrower list that the title insurers are suggesting. Now, I'm currently in the process of rectifying at a title insurer's expense a title error made in an internal reorganization that happened one deed prior to the share transaction. And the mistake was definitely known to the insured company. It did the reorganization. But because of the non-imputation endorsement, the title insurer is paying the cost of fixing that. Third category is value. And there are a whole series of endorsements related to the amount of insurance purchased. On the loan policy, it's pretty easy. You want to have enough coverage to repay the loan. The amount of the insurance is the same as the amount loaned. But that gets more complicated on the loan side when the loan is given on security of both real property and other assets. Every title insurance policy has a provision called limitation of liability, which limits liability for a loss to the amount of insurance purchased or the reduction in value of the property due to the defect. Okay? So if you have a total loss of title, the amount paid can't be more than the value of the property. So there's no point with a lender paying more for title insurance than a property's worth. He's never going to recover that money. In an owner's policy, it's more complicated, because just like your own home insurance policy, there's a co-insurance provision. So if you buy title insurance at less than 80% of the value of the land at that time, or your client puts an improvement on the property that increases the value by more than 20%, then the owner of the property becomes a co-insurer with the title insurance company and bears a portion of any loss. So having the correct amount of insurance, thinking about the price related to the related to the fair market value, asking your client about plans to develop the property are important. If there's enough concern about chosen value in situations where the price is set on some value other than fair market value of the property, and lots of the transactions I've dealt with, it's been done on sales. How many donuts were sold at a certain spot, set what that price was. Then you should be thinking of getting a co-insurance endorsement which deletes the co-insurance provision. Not surprisingly, there are lots of endorsements that are issued by title insurance that allow the purchase of future title insurance. Okay? And these are examples here: future improvements, commercial inflation, increased insurance, subsequent insurance, all of which say that the title insurer is glad to get more money from you at some later date. There are, however, a series of endorsements that relate to special uses or characteristics of the property that add to its value. And special measure of damage endorsement, going concern endorsement, leasehold improvement endorsement are all situations where you might want to buy some additional insurance to make sure you've got coverage for the particular value of this property. Now, generally, I've been pretty fortunate when I've had to deal with the value questions, because most of my title insured transactions that have had value issues have been on multiple sites. And there is an endorsement that's at pages 13 through 17, the aggregation tie-in endorsement, which totals all the values on all the issued policies, deletes the co-insurance provision, and permits a claim to be made against the aggregate amount. So if you have 10 properties, $100,000 each, you have $1 million in coverage for any harm on any one property. In the acquisition of shares in Tim Hortons, we were title insuring 650 owned or leased sites. And given the cost of title insurance, the insured wanted to make sure that they were valued at a very low level. However, once the title insurer was comfortable with the way the value was settled, it was delighted to receive the substantial premium, gave the aggregation tie-in endorsement, and the co-insurance provisions were deleted. All of the value questions became irrelevant. Next category is a loan policy, and there's lots of detail there. I think that what you'll find is that a loan policy works real well for a standard mortgage. But if you've got particular characteristics of your loan, if it's a complicated commercial transaction, it needs to be tweaked, adjusted to fit the loan situation. So you should be reading through the loan package, seeing what the various elements of it are, looking at these questions, looking at section 2 to see what the descriptions are, and trying to get the coverages that match the loan situation that you're dealing with. The nice thing about that area actually is that most of the time the lenders are doing this themselves, and you don't have to go advise them. They come in and say, oh, I work with First Canadian all the time. I've got these 12 endorsements that I want. So it's not something that you do spend a lot of time on. There are a few things, though, that you do need to talk to them about. One is, for every lender, they should be getting what's called a comprehensive or restrictions, encroachments, and mineral endorsements. It covers all the things that are shown at page 52, and every commercial lender client should be getting one. There are a series of endorsements that are shown here that relate to the special characteristics of the property. And if you see those characteristics, you should be talking to your lender client about getting that coverage. And finally, despite the fact that loan coverage runs with the land, it doesn't cover anything after date of policy. So if you're dealing with a subsequent assignee, you'd want to make sure that you get the assignment of mortgage endorsement so that that later assignment is title insured as well. Okay. Section 5 deals with title property problems. And basically there you're looking at what the list of exceptions is. And there are some, like the 7 that are shown here, that are pretty standard for title insurers to do. You should be looking at those and consider deleting the first 3, okay? And which of the survey ones in the last 3 are appropriate. And that leads to those 2 questions, the second and third question there. If there are specific exclusions in the title insurance policy, Schedule B, you should be thinking about having them deleted or insured over. Remember that when you get them insured over in a title insurance policy, you're going to be getting variations of the marketability endorsement, the limited marketability endorsement, or the future insurance endorsement. A title insurer does not solve problems. A title insurer just says you can sell the property. It's marketable. It just says, I'll offer a title insurance policy to the person that purchases the property from you. So it is that style of coverage that you're going to be getting. As you can see, there are a whole list of specific endorsements that fit specific kind of title problems. The sixth category is policy issues, where you might want to amend the basic policy terms. The first group of those are ones where the policies are different from insurer to insurer, and you should be looking at the differences, telling your client about them, and considering whether those endorsements should be obtained. The second category is where there are particular factual circumstances where certain policy terms might be inapplicable. The third is basically for clients that are American and aren't familiar with Ontario laws, and there are endorsements that are adjusted to their needs, doing business, tax law, environmental liens, because they're not familiar with the way Ontario laws work. And the last group are endorsements that seem to have arisen because people have had in the past difficulties with title insurers over certain issues, and these are clarification of the policy. There's a whole category 7 which deals with American insureds, and I include it as a category because that's something that I often do, and I wanted to group the ones which seem to be where they wanted to get title insurance policies that look just like the policies that they saw in the States. So if you deal with American clients, I wanted to make sure the grouping was there. And finally, in miscellaneous, there are 4 categories that I wanted to, types of endorsement that I wanted to speak about because they just didn't quite fit into other categories. One is the gap endorsement. One of the big advantages of title insurance is the ability to close and advance or loan funds without waiting for registrations to be completed. Okay? The title insurer takes the risk. This is particularly useful in any complicated transaction, and the gap endorsement at page 34 or a proper title commitment is a way to handle that. Second, a title insurance policy works really well for owned property, but it doesn't suit too well leasehold interests. In the United States, they've tried for years to get leasehold policies and other variations, and then in 2001, they put out new leasehold endorsements, which pretty much do the job. Those are available here in Canada, and other than one problem with one of the loan characteristics, which is written in the paper, they are pretty good coverage. And finally, if you've got a commercial condominium, there's a condominium endorsement that deals with those problems. But to be fair, while I've been writing this paper and working on all these title insurance questions, there's a whole other series of questions that have been troubling me a lot. 4 of the key ones have to do with Nolan, Sundin, McGillney, and Balfour. And working with title insurers and endorsement is a creative process, but I haven't been able to find a title insurer that will provide me with the endorsement that I need for the Toronto Maple Leafs. So I'm just going to have to watch and worry about it a little more tonight. I'm sorry that there has been so much content. It feels to me like it's been a race. You're going to have to sit down and read this material. I hope that you find it useful and is of some guidance. I know that doing it was good for me, and I look forward to working with it myself. Thanks.
I have to say, just by the applause, I think you struck a chord or struck a sense of fear in the hearts of all of us. I'm reminded at the same time I was listening to of everybody remember Annie Hall, the movie, and you know Woody Allen was sentenced to jail, and part of the sentence was he was put into a cell with an insurance agent for It's now my turn to take us up to the break, and I'm going to be talking about what real estate lawyers get sued for. As you know, or may know, a good part of my practice is acting on behalf of LawPro in connection with claims made against real estate lawyers. And what I do, being sort of having half a foot in the real estate camp and sort of being a closet litigator, is look at the claims, give opinions, strategize, see if we can fix them, and if somebody doesn't want to get sensible with me, I give it to my good litigators who go beat them up. But in the course of this practice, I have seen lawyers get sued for, or have claims made against them for things where I would say, there but for the grace of God go I could have made that any day of the week, make that mistake, and others where you sort of think like, what the hell was that person thinking? So it goes across a range, but one of the things I've learned in this practice is don't be smug about other lawyers making a mistake, because as they say, when you least expect it, it can happen to you, and you say, I just didn't see it coming. A couple of years ago, actually about 10 years ago, I did a paper on, again, what do lawyers get sued for? And it was a real lawyery thing. I mean, I talked about breach of fiduciary duty and duty to warn, and I'm not going to talk about that. I'm going to talk about blood and guts today. I'm going to talk about what really goes on. But there's one last thing by way of introduction, and there's a title insurance has added a dimension to claims, and it's this. You've now got somebody else, in addition to Law Pro, who is looking at you and seeing whether you're good, bad, or somewhere in between in terms of your practice. And title insurance isn't the easy answer to the fact, well, it's title insured, so, I don't have to be as careful as I was before. Because this is what happens even on a title insured claim. Number one, your client is still pissed off at you, okay? They're the ones who have a problem. Your answer is, don't sue me, take it up with the title insurance company. But in the meantime, now your client is looking to you to intervene to get the protection out of the title insurance company, okay? And you still, at the end of the day, might get sued. So don't look at title insurance as, well, I don't have to do this, or I don't have to do that, or I don't care, because at the end of the day, it's your client who is really looking at you. So, first topic. There's things in the paper that I'm going to be talking on. There are also things that are not in the paper. As I get older, as I lie awake at night, wondering how my kids are doing, how my family is doing, what the dog is up to, and where's my next file coming from, I also think about things to add to this paper. So some things will be in the paper, some things not. Let's start. Leasing. Leasing is a really interesting issue for lawyers. If you're a landlord's lawyer, you rarely get sued. There's not too many claims against landlord's lawyers, but there are claims against tenant lawyers, and this is how they materialize. Number one is zoning. We have seen a number of claims where a lawyer looks at a building, looks at an office building, for example, sees the agreement of purchase and sale, and it says office. Well, in this one, nice office building. Didn't check the zoning because it was obviously an office building, but the proverbial hit the fan when the purchaser wanted to rent out a number of the offices to doctors. It happened to be located in an area close to a hospital, and seemed to make sense, except for one thing. In North York, the zoning bylaw has a different definition for professional offices and medical offices. And a professional office is anybody other than a doctor or a dentist. So all of a sudden, this building, which had tremendous potential because it was located close to a hospital, didn't. And the lawyer did not check the zoning carefully enough and compare it with the agreement of purchase and sale, or caution the client that what the client's expectations might have been was totally different than what the city of North York thought for the use of this building. We had another situation where the agreement of purchase and sale called for commercial. And in this building, it was a 4-story building with ground floor commercial. There was a hairdresser, a variety store, a bank, a barber shop, and a variety store. Those were the tenants. It was a smallish building. Well, the hairdresser went out. Video store went in. This was a great deal, except for one thing. The tenants in the building complained about the amount of traffic generated by this video store, and it turns out that this property was not zoned commercial, although it looked pretty obvious. It was spot zoned for a bank, a variety store, a hairdresser, and whatever else I said, okay? But certainly it was not zoned to permit anything other than those 5 designated uses. Well, not only did the landlord have a problem in renting the space out, but he'd already rented it to the tenant, which takes us to the tenant side of things. And that is, just because it looks like it's commercial, it may not necessarily be commercial. So when you are acting on behalf of tenants, and we'll come to that in a little bit more in a second, rather than what I would say, not seeing the forest for the trees. This is what forest for the trees is when it comes to lawyers reviewing leases. We all understand this. Client comes in and says, here's my 30-page lease. Please review it and tell me what's bad in it. And your budget is $1,500. Don't spend any more than that. So our general inclination is to, yes? Or is that the $1,500 too much? Yes. All right. $500. $500 okay? So what the heck do you do with a $500 budget on a 30-page lease? Well, some lawyers' natural inclination is to read every word and think that they're doing a good job when they keep adding the word acting reasonably here and there throughout the document. But we have seen, you know what I'm talking about, but we have seen claims where the lawyers were so focused on the document they weren't focused on the use. And you have to be careful when you're talking to your client. Sometimes it may be obvious, but the video store file ended up being 2 claims, one by the purchaser and one by the tenant, because the tenant had spent a whole mess of money setting up the video store, was then evicted. He had to leave because he couldn't get a variance. All the rest of the tenants in the building were screaming blue murder. And he also had a claim against his lawyer who reviewed the lease but never checked the zoning. So zoning for tenants is critical. Takes me to the next thing with regard to claims against lawyers, and that is, what do you do when the client gives you a $500 budget and a 30-page lease? I think the most important thing that you do is you qualify your opinion at the outset and do it in writing. And don't be afraid to say, look, you gave me 30 pages of legalese. You only want me to spend $500 of your money. I can only give you a general overview. I can skim it. I can look for some things, but I'm not going to look at every word. I can't do it. So qualify your opinion and then also tell your client, I'm going to tell you things that I think might be important, unless you tell me that there's something really that you want me to look for. And that way, you're putting your own spin on what may be important, and then you give it back to your client and say, this is what I can do for you, this is what I cannot do for you. And let me give you an example. And in my paper, I've given a checklist of things. The Chayton case is referred to in my material. The Chayton case was a case where a lawyer was sued for supposedly not advising his client that in the lease was a demolition clause. The old Dye-and-Durham form demolition clause says if the landlord wants to demolish or sell or substantially renovate the property, tenant can be evicted on 6 months' notice. Well, that's a pretty bad clause. And in this case, the lawyer was sued, and the court found that the lawyer had done a good enough job to alert the client to that particular clause being in the lease. This is the way I do it, and you all may have your own ways of doing it. I don't send huge reporting letters out to clients on leases when I've got a limited budget. What I do is I take the lease and I handwrite my comments on the document. Okay, so I'll put beside a demolition clause, I'll say, delete this clause, this is very bad. Where it talks about what the common expenses are, what the additional charges may be, I may say where it says, as we learned yesterday, admin fee plus a management fee. Too much should be deleted. beside the gross up. You are paying rent not only on your space, but on your area, percentage area of the common areas. And I'll just handwrite these notes on the document. I will say, here, these are my comments, this is my review. If you want me to do more, then let's talk. But at least that way, that document, the lease itself, becomes my reporting letter, and I don't end up having to review the document and as well send my rear end letter to my client. Next leasing issue is one that is fairly common, and that is renewal dates. You've got 6 months, notice to renew. I always tell my client in my standard letters, I don't monitor diary dates. You're on your own for renewals. Make a note of it yourself in your calendar, but I will not be responsible for that. I do the same thing with PPSA, by the way, and that is, we all know PPSAs expire at a certain point in time. I specifically tell my clients, I don't monitor those dates. If I've registered a PPSA for 10 years from now, I ain't keeping track. Thanks very much. You're on your own. You diarize it, and you call me before that PPSA registration expires. We've seen claims against lawyers for lapsed PPSA renewals, and that's the way we cover it off generally in the office. Next topic, I'm gonna really zip along here. GST. We've seen lots of claims with GST, and it all relates to this question, two questions actually, included in the purchase price or in addition to the purchase price. That's where you're using a TREB form or Ontario Real Estate Association form of agreement of purchase and sale, and somebody has filled in the box that says purchase price is included. If it is a property that is taxable, understand by the GST being included, instead of the purchase price being $100, the purchase price is $93.45. We'll call it $93, okay? Because it's $93 plus the 7% tax gets you to $100, okay? That's if the purchase price is includes the GST. Now here's the problem. The purchaser thinks that they should pay, you end up into a problem whether the purchaser is registered or not registered. If the purchaser is registered, on closing, the purchaser only pays the vendor $93. Vendor is pissed off. He says, where's my $100? I sold it for $100. You as the lawyer have to explain to the client that with a GST inclusive deal, at the end of the day, they're only netting $93. And somebody is to blame, and hopefully it's not you, for the word being in addition to or inclusive of GST. The second aspect of claims, and you'll see it in my paper, there's about a page and a half on what the drill is. The second aspect is in relation to who collects and who pays. If a purchaser is registered on a taxable deal, the rule is vendor make sure that the purchaser is registered. Don't worry about all this indemnity nonsense. It doesn't matter. If a purchaser is registered, the Act says the purchaser self-assesses. So what you as a vendor want to do is make sure the person's registered. And we've seen a claim where somebody got that usual certificate or statement that says, yes, I'm registered and here is my number. Turns out it wasn't their GST number, it was their income tax number. And they weren't registered, and it's a separate registration. And in my paper, there is a phone number that you can call to GST, and I give credit to David Sherman, who knows more about GST than anybody in the world, for giving me that number. And apparently you can phone the nice people up at CCRA, and they will tell you if a particular person is registered. Do not believe or rely on the purchaser's statement unless you see the actual registration form. Next topic. I'm moving fast. Next topic, Water boundaries. Izaak talked about boundaries. I'm going to give you my own spin. Water boundaries isn't in here, isn't in the material, but just make a note of it. I'm going to give you my own spin on water boundaries, and that is there is no such thing as a water boundary. What appears to be the line where the water meets the ground moves all the time. And it's not necessarily the case that the water line is the boundary of your client's property. It could be in the water. It could be 10 feet up from the water line. There is a lake around in the Kawartha. It's called West Lemcoon Lake. I don't know if anybody's ever heard of it. West Lemcoon Lake is a great lake because the boundary of the property and where the waterfront is, you would think that's lake. Or like you can go swimming off the dock. It's private property because West Lemcoon Lake is higher by 12 feet as a result of what they do on the Trent system. So when you think you're buying property adjacent to water and you want to put in a dock, well, guess what? The registered owner of the bed of the lake has a right to object to the improvement on his land. So be careful about water boundaries. A lot of the water boundaries, a lot of the lakes are regulated. They're up and down with dams and everything else. So even the reference plan, even the survey, while it may show you a theoretical boundary, make sure you qualify your opinions with your clients. Next stop, occupancy permits. These are nasty little suckers. And there are some municipalities, not in the paper, just hit me about 3 o'clock in the morning. Occupancy permits are issued by some municipalities. Make sure you get them. I think it's Markham issues, in the Toronto area, issues occupancy permits, and without it, they can come along and say you can't live in that building. And we've seen a claim where somebody really built a very a poorly constructed property, but it was one of these mega homes, and everything from the footings and the foundation on up is just bad, and the damage claim is coming in at about $800,000. So that's, and everybody wants to blame the municipality. Question is, was there an occupancy permit issued? That's what the nice municipality says, and then everybody says to the lawyer, what the heck were you thinking? You do work in Markham, know that they have occupancy permits, and you do not close deals without occupancy permits. Title insurance. I think title insurance is going to be the next big wave of claims, and here's the reason why. We rely on it, or we give an opinion to the, well, I don't think you'll find that in there either. I don't even know what's in that paper anymore. But you'll see it. It's there. It's somewhere in there. Title insurance is the next wave of claims I think we're going to see, because we're seeing situations where the lawyer doesn't get title insurance. And the client says, you should have told me to get title insurance, because if I had title insurance, this wouldn't be my problem. Okay, so that's the first set of claims. Second set of claims, it's the reverse. What was the big idea getting a title insurance policy? You knew that I cared about zoning. I was very concerned about this, and you should have done the search. You say, well, title insurance, I don't do searches. I don't search zoning. If it's residential, it's residential. The title insurers tell me not to search. He says, yeah, but if you had done the search and would have told me that the property was hazard land instead of residential zoning. True claim. House is sitting on and then subsequently zoned hazard land. Okay? It's in a nice neighborhood out in the Caledon Hills someplace. It's beautiful, except for one thing. You can't add to it, and who's going to buy it? He says, I would never have closed this deal if I knew. The lawyer got title insurance. Okay, so what's the client supposed to do? So that's a problem. It cuts both ways. And then, of course, Bruce McKenna, bless his heart, has just told us that we have to think about 750 different endorsements when we do a deal. And God help us if we don't get the right endorsement. Like I said, we've now become insurance agents for our clients, because we're the ones who are really calling the shots, or at least thinking about what endorsements we should have. Planning Act. Don't make fun of the Planning Act. It's just, I've made one heck of a good living on the Planning Act, let me tell you. Planning Act. The Accioni question keeps coming up, and the claims keep coming in. Here's the story. Forget you ever heard the words, once a consent, always a consent. And don't even make up that other expression, once a severance, always a severance. Parcels A and B. A is conveyed with consent from owner to herself. Severs A and B, and then conveys B, the unconsented parcel. When B is conveyed, the owner still owns A, right? Still owns the abutting parcel of land. That contravenes the Planning Act. Subsection 12 says, where land has been conveyed with a consent, you do not need a consent to deal with the identical parcel of land previously conveyed with the consent. So you can convey parcel A, the consented piece, all day long. B, not. Okay? Does not flow with both properties. The Court of Appeal has confirmed it, and they've also confirmed that subsection 6 does not apply in that situation. Next, another topic near and dear to my heart, and that is fraud. You have seen the LPIC special report on fraud. There are two types of fraud. There is identity fraud, and there is what is now becoming an even nastier thing, and that is the Oklahomas and the flips. Identity fraud is easy for you to deal with, and that is you make sure that you get ID. Now, what kind of ID works? Well, I was at a meeting with the police a number of months ago, and we were talking about fraud, and they said, driver's licenses, citizenship cards, those are easy to forge. Nobody ever forges a library card. So if there is a message here, here is the message, okay? Ask for 2 pieces of ID. Yeah, I mean, it really happens when you're dealing with strangers. You know, you've known these clients for years and years and years. It's not where it's going to happen. But when you're acting for a lender and somebody comes in you've never met before, or a client that you've known for a long time comes in with his or her spouse whom you have never met, do not be embarrassed to ask for ID, to make copies of it, and to make legible copies of it. I have seen, I don't know how many fraud files where you can't read the information on the ID. It's great you took a photocopy, but you can't see the picture. It doesn't make sense. Lighten it, darken it, whatever you have to do. Make it legible, make copies, and get 2 pieces. Say, I'd like to see your wallet, thank you very much. Now, I'm being facetious, but let me tell you, fraud is costing the law pro, and it is costing the title insurers who are really getting whacked, and it is costing the Land Titles Assurance Fund millions and millions of dollars. It boggles the mind, the extent to which fraud has become big business. We're not talking about the gambler who's got a problem and he brings his girlfriend in to sign a mortgage and he gets caught and starts crying 6 weeks later when it all comes out. Okay, we're talking about big business, organized crime. The money on these deals is out of the country within 24 hours. On the Tesoro frauds, that money was gone. It was in the Bahamas, and God knows it was turned into stuff you blow up your nose in literally 24 hours. So be very mindful of it. My materials, because I'm running out of time, my materials have a number of flags. It doesn't mean everybody is a crook who walks into your office. But if some of these flags are a little bit cumulative, like, why are we doing this deal so fast? And you just bought this property a month ago, and now you're putting a mortgage on it, but you don't want to go back to the lawyer who did the deal, and you're telling me you'll pay me extra? Nobody wants to pay a lawyer extra. Okay, you'll pay me extra to do it real fast? then maybe you should start scratching your head a little bit. Same thing on the Oklahomas. When a client comes to you with an agreement of purchase and sale where the agreement hasn't got a mark on it, where you see that the vendor just bought the property a few months ago, where you see that the price is going up by $50,000 or $75,000 from what it was purchased, and when you see that the vendor is giving a big VTB to the purchaser, purchaser giving a big VTB to the vendor so there's no cash closing, changing hands, or a big abatement in the purchase price, then something's phony with the price. And what they're doing is they're bilking the lender who is lending on the strength of that inflated agreement of purchase and sale. And somebody mentioned to me yesterday, CMHC and all of these lenders, they are not doing appraisals, or they're being very very casual about appraisals. So don't necessarily rely on the fact that you've got a sophisticated lender out there. The lenders want one thing. They want to get their money out on the street as fast as they can. And what they are saying is, due diligence, we'll let the title insurers pay for it. Okay, and the title insurers are now saying, the buck's got to stop somewhere. Which gets me to the next topic, and that's powers of attorney. The more I know about powers of attorney, the more I don't like them. And I'll tell you why. The classic cases were the ones that Reuben Rosenblatt, who's here somewhere, talked about, and that is parents give their child a power of attorney. Power of attorney, the attorney runs into financial difficulties, mortgages the parent's house. The lawyer knows that the money is being used for the benefit of the child, the attorney. And the question is, does the lawyer have a duty to inquire as to the use of the money or the use of the power of attorney? Or because it's an unrestricted power of attorney, can you just sort of say, hey, if parents want to give an unrestricted power of attorney to their kid, it's their problem? Now, some people say, yes, that's obvious. And others say, no, the lawyer has some duty of inquiry, some duty to the parents. Here's what I really don't like about powers of attorney. They're being used fraudulently. They're being forged. There is nothing to prevent somebody coming along and saying, I have Sid Troister's power of attorney. I'm putting a mortgage on his house. And here's my power of attorney. And it has my signature on it. No, it doesn't have my signature on it. It has some forgery for my signature on it. And they walk into your office, and you're acting for the lender. You're going to rely on that power of attorney? The powers of attorney are stupid documents when you think about it. Two witnesses. And who are the witnesses? Scribble. With two names. Who are these witnesses? How do you prove that a power of attorney is really a power of attorney, and yet we act on them all the time? So you may want to rethink what you do with powers of attorney in your practice. Two last little things, because my time is up, and I'm the watchdog. I'm the policeman, and my time is up. Standard charge terms. I have said this over and over again. Standard charge terms 9320. That's the Dye-and-Durham form. I will blaspheme them. And 2033, which is the E-Reg form of the Dye-and-Durham standard charge terms. Anybody who is old enough to remember will remember that in the boilerplate mortgage, the standard mortgage, there was never a due-on-sale clause. That due-on-sale clause was something you bargained for in your agreement of purchase and sale or in a mortgage commitment. In 1993, Dye-and-Durham thought it would be a good idea to add Section 14 to their standard charge terms, which contains a due-on-sale clause. Now, that's great if you're acting for a lender, because it's a lender-biased document. But what you've got is this problem, and that is you're acting on the purchase of vacant land for development. And you're going to pay a very pretty penny to the nice farmers who are selling the property to you, who are also prepared to give you a very juicy deal on a VTB. Interest-free for 3 years. Interest-free for 5 years. 2% interest a year. And 2 years later, you want to sell that property and let the purchaser assume the mortgage. And you're the one, because you're the purchaser's lawyer, you did the VTB. Well, guess what? Smart lawyer on the other side says, oh, no. You asked me for a mortgage statement. Here's my mortgage statement. I want all the money now. Thank you very much. It's due on sale. Paragraph 14 of the standard charge terms provide for it. So if you're dealing with a VTB situation in particular, watch out which standard charge terms you use. We have had 4 situations now, at least, involving VTBs on development land where the VTBs had very favorable interest rates, and the vendor's lawyers got wise to it and said, I'd like all my money. And, of course, the purchaser's client said, where were you protecting me on my VTB? Last thing, and this is really ugly, and it comes up, it's just come up recently again, my last point, highway access permits. Highway access permits are governed by the Public Highway and Transportation Improvement Act. It's something like that. It's in my material. But what it says is if you are dealing with property that is located on a King's Highway, you need an access permit, or you cannot go from your property to the highway. And the ministry has very strict guidelines, and access permits are not assignable. They are not transferable. So if you've got a deal where somebody's buying a business, for example, make sure that it's conditional on your client being able to get an access permit, or you've got a problem. The situation that I'm dealing with right now, in 1993, the property was severed. The ministry was given notice. Ministry of Highways, MTO, was given notice of the severance application. They did not object. 10 years later, on a sale of the property under power of sale, the ministry says, there's no access permit. We didn't approve that. And by the way, you've got a driveway and an access that's 35 feet. You need 105 feet, so we're not giving you a permit. So those are nasty if you're dealing with any property on a King's Highway. Watch out for that too. And I'm done. We will see you in about 20 minutes.